Highway and Transportation Authority et al.
May I please support?
Why don't you wait a moment and we'll let the courtroom settle down. Mr. Frontera?
This is Attorney Juan Manuel Frontera. May it please the court. I represent the appellant in this case, Ms. Sonia Velez-Velez, and her husband, Pedro Rodriguez. This is, I would like to reserve 2 minutes for rebuttal.
Yes, you may have it.
I'm sorry. This is a political discrimination claim for Puerto Rico. I know this is a topic that comes forth to this first circuit often.
Yes.
And this circuit has dealt with it and knows the standards and knows the issues that this type of cases come. So I will go straight to the issues with respect to our brief.
Okay, let's start with the statute of limitations. Sure. The district court viewed this as a case much like the Ricks case, where notice of intent to terminate is given along with some language that, and of course you have due process rights, you can get a hearing. And it's clear that suit was not brought within 1 year of that notice of termination letter. And so your argument is that despite Ricks, there was no problem with the later lawsuit.
The issue is that Riggs does not deal with a Laudermill hearing. The case in Riggs is a different type of hearing than a Laudermill hearing. In this case, there is no dispute that on the February 10th, 2010 letter that Ms. Sonia Velez received, she was advised that she had, and the letter states specifically, that prior to adopting a final decision, you have a right to an informal administrative hearing. That is a Laudermill hearing. In the case of Riggs, the grievance procedure that was presented in that case, in the Supreme Court case, was a remedy for a prior final decision, not an opportunity to influence that decision before it. That is Riggs at page 261 and 262. So the hearing, the February 10th, 2010 letter that my client received, informing her that she had the opportunity to go to an administrative informal hearing, is a different procedure than the one stated in Riggs. She had the opportunity to influence the decision because the decision was not final.
The decision in this case was based upon a series of administrative rulings having to do with whether her appointment was null and void. It wasn't in particular to her. It had to do with a category of employees. And the notice says, and so in compliance with our law, we are notifying you that your original transfer was null and void, and consequently to order that your service be terminated. And then it says, in accordance with state law, you have a hearing on this. But in fact, what was she going to argue at that hearing? That she wasn't, that this ruling of law was wrong?
Because what was...
Is that what her argument was?
The determination, the ruling, the final determination of law was wrong. She had the opportunity to present before the corporation in an administrative informal hearing that the reasoning of the corporation under law was wrong. And the corporation is giving her, is advising her that she has the opportunity. This was not a final decision. And plaintiff has, in this case, Sonia Velez had a property interest over her employment. And having a property interest over her employment, she has a right to an informal hearing on the Laudermill. And that was the corporation, what they did. If this court established a difference in different type of Laudermill hearings.
So under your rule, it isn't until she's been through the full hearing and the notice of termination has been effectuated and she's actually been terminated, that's when the statute of limitations
That's the final
starts.
decision. That's the final decision
Okay.
that Rick's talk about.
Counsel, I need you to just dig into this because I couldn't figure it out from the briefs.
Yes.
Is her argument that if what she would have presented at her hearing, would her argument have been that in fact her transfer was done pursuant to a merits-based evaluation, or was her argument that at the time she was transferred there was no merit-based decision required?
No. What she would have presented, I think that.
And she did have a hearing, so you know what she did
Yeah.
in fact present.
Yeah,
What?
I think the I don't know if it's in, but it's in the docket. She presented that the analysis made by the corporation first in enacting the resolution that declared null and void other resolutions of the corporation, because what we have here is that the corporation enacted a corporate resolution in 2001, okay, authorizing the corporation to make transfers from Puerto Rico agencies to this public corporation. And what the corporation did is that in 2010, they approved a resolution leaving without effect the resolution of 2001. And by leaving without effect the resolution of 2001, declaring null and void all the transfers that were made by those. And what my client presented is that she complied with the regulations of the corporation at the time the transfer was made, and that the resolution of 2001 was a valid one under the law. Now, she had the opportunity to present that to the corporation and say, you're making an error. You're committing an error.
Okay.
Don't do it.
Okay, but this error is in common to a whole lot of people. And what she's saying is your legal reasoning is incorrect. She is not saying, no, you're wrong because I don't fall into this category of employees. Correct?
No, she was clear that she was under the resolution of 2001 that was left without effect.
Okay.
But be that as it may, the final determination was not February 10th. And it is clear from the record that the hearing that she had in the summer of 2010 was a Laudermill hearing. No, it was not a Riggs hearing.
Okay. Thank you.
Now, with respect to, so our proposition is that the case is not time barred, and the statute of limitation began to run in December when she received the final determination. With respect to the other issues, I know this court can review de novo the entire case with respect to summary judgment, as this court decided in Ocasio versus Fortunio Orset. But I will leave it.
Go ahead.
I just have one more question. So there was a whole group of employees who got a similar notice. Is that correct?
Yes.
And was everyone then who got the notice notified that they nonetheless were entitled to an individualized hearing? Not
Yes.
a group hearing to contest the legality of the 2010 resolution, but their individualized hearing.
Yes, Your Honor. And all of them were PDP employees.
Yeah. That goes to the merits of
Yes.
the case. Right.
Anything else going on with that?
Huh?
Is anything else happening with that besides us?
Is there litigation in the state court system, in the Puerto Rico court system?
No, there's an administrative process, an appellate administrative process. After that informal hearing, she filed an administrative process.
Okay.
And that's ongoing?
Yes, that's ongoing.
Okay.
Good morning. May it please the court.
Good morning.
My name is Jasmine Gonzalez, and I'm the legal representative for the Puerto Rico Highways and Transportation Authority and the defendants in their official capacity, Hernandez and Gomila. Your Honors, I would like to first state that in the administrative proceeding, just for the court to be clear, the plaintiff was reinstated in her job. So as now, she's working for the TSA. So we would also like to...
Wait a minute. That would moot this case. Counsel, has she been reinstated?
She's been reinstated as a process of settlement in the process of this appeal. But the damage in the political discrimination claim and the damages under that is still ongoing. She was reinstated to her job, but she has not been...
With back pay?
No,
All right, so this is about back pay?
Back pay, yeah, and damages under Puerto Rico.
Yeah, okay.
She was reinstated as a result of the settlement hearing in the process.
Okay, thank you very much.
Thank you, Your Honor. We would also like to address the issue of the judgment as to the time bar defense. We would like to distinguish the case that actually the plaintiff and appellant in this case used to, as third issue to be reviewed by this honorable court, that is the case of Baltodano. We would like to only draw the attention of the court that in that case particularly, yes.
Was she reinstated as a result of an administrative decision? Or was she reinstated, because if it was the result of an administrative decision, doesn't that strengthen their argument that the February notice wasn't final?
Your Honor, there was
and that there was an opportunity for her to present evidence which would have been relevant to the reinstatement of her job?
Your Honor, no. There was two proceedings going on at the same time. So there's the administrative proceeding and the proceedings in this case. As part of the settlement of this, the settlement intents of this case, the employer decided to reinstate this plaintiff. Nevertheless, the issue as to the back pay and other damages and other claims that were pending, still pending. There were no agreement as to that effect, Your Honor. And I'm not the attorney of the administrative proceeding. Nevertheless, the administrative proceeding hasn't concluded yet.
My question.
You want to ask it again?
I'm going to ask the question again that Judge Thompson made, because frankly, she receives a letter telling her that she is entitled to administrative hearing.
Yes, Your Honor.
Okay. A decision adverse to her is made.
Yes, Your Honor.
She appeals that.
That's correct.
And that decision below, the administrative decision, is reversed and she's reinstated. Am I correct on those facts?
No, Your Honor.
No?
No.
All right.
No.
Tell me what happened.
No. She's reinstated in lieu of the settlement efforts in this case, not in the administrative proceedings, Your Honor.
You settled everything in this case except for back pay?
Back pay and damages, correct.
He just said that was a result of the administrative appeal.
No, the settlement hearing that this court has before Judge Cordero.
Yeah, exactly. That's part of this case, Your Honor.
So our settlement office was able to bring you folks to a resolution on reinstatement. Is it of this plaintiff alone, or what about I know that's not before, what about the other folks who got the layoff notice?
Answer, go ahead.
Sorry. We represent other plaintiffs from that group of employees that was dismissed, and that plaintiff also was reinstated as part of the process. So, but it was a mediating issue that the they decided to set up only the issue of restatement and leave the case go through with respect to back pay and damages.
So is the administrative proceeding, the appeal that she took to the administrative decision, is that stayed?
Yes, Your Honor. Although it is pending, it is dormant.
Is it stayed pending resolution of us deciding something?
No.
No, Your Honor, no.
Well, what's
Because
stayed?
they don't have the capacity to establish
Damages
to
or
damages or
exactly.
discrimination.
So wait a minute. As a matter of Puerto Rican law, if she were to go into this administrative hearing, they could reinstate her, but they could not give her any back pay as a matter of Puerto Rican law? Is that what's going on?
Well, Your Honor, as part of the administrative proceeding, she will be entitled to reinstatement and any other license or maybe back pay that he will be entitled to.
So under state law, put aside this lawsuit, if she were reinstated, she could get back pay.
Your Honor, she will be reinstated and she will be, accrue any benefit that she will be entitled to. That will be the administrative hearing.
Is she under Puerto Rican law? That's a simple question.
Yes, Your Honor.
Would she be entitled
Yes, Your
to
Honor.
back pay?
Back pay, yes. Damages, no. The issue will be the date of the back pay as determined whether the evidence show in the administrative proceedings.
Okay.
That will be.
All right, let me go back to the hearing. When she went into that hearing, she could have theoretically been reinstated as a result of that hearing?
Well, as to my knowledge in administrative proceedings before governmental entities, the official examiner will be in charge of determining whether the employee was supported its position. It's the opportunity for the employee to show that she has proof to rebut the intention that was already contained in the notification letter, in the termination letter.
And if she met her burden in the eyes of that examiner,
Well,
she could
if
be reinstated to her position, right?
she could be, but the official examiner, what the official examiner does is it makes a recommendation to the secretary that in the end is the
Could the examiner have reversed the legal reasoning on which she was being told that she was being terminated?
I don't think so, Your Honor.
No, I don't think so either.
I don't think so, Your Honor.
She could have proved she was not in the class of people to whom this legal...
That's precisely the
But that is not her case. She concedes she's within this class of people. She is just saying the agency is wrong in its legal reasoning.
That's correct, Your Honor. And the thing is that this
And what my colleagues are getting at in part is that if the agency were mistaken and she was not in that class of people, which sometimes happens, if she could prove that, then she could get reinstatement with back pay, so that the RICS problem may become more refined in terms of what it is she's actually arguing.
Yes, Your Honor, but the important thing here is to let you know that there will be actually, from the outcome of the administrative hearing, there will be no back pay because she was not suspended from her job. Okay? From the notification on February 2010 to the hearing that was on December and the final determination that was on December 23, 2010, she was working. She was not suspended.
Yes, of course. They say it's our intent to terminate you after you have this hearing.
Exactly.
Okay.
The hearing, by its nature, is a remedy to the prior decision, not an opportunity to influence the decision before it is made.
The hearing, Your Honor, it's a way to give the due process to the employee as required by the state law.
I was reading from the Supreme Court.
In Riggs.
Right. Thank you.
Thank you, Your Honor. Morning. Michelle Camacho on behalf of defendants in their individual capacities. Honorable Court, this is the first time something like this happened for me. I'm probably sure for other counsels too. But the way these things developed, sister counsel was not part of the settlement process. And the reinstatement that she brought up to this court was part of the confidential settlement agreement that the parties agreed not to brought before this court in order not to influence the decision of this appeal. So she was not part of it and it was brought, but I just want to feel the need to say something.
I don't understand.
No, go ahead. I have a question, but
You mean it's sealed? The fact, is this a public fact that she has been reinstated? Okay.
You think
All right.
They're working there. They're working at the corporation.
Okay.
isn't there a harassment claim involved here also?
Yes.
Well, is that time barred?
It is time barred because all the elements and the events that she described in the allegations and on brief are confined to a certain period of time that ended in March 2010. And the complaint was filed in December 2011, more than a year passed after the last event of harassment happened in the court, in the authority.
Right. So your view is even under the continuing violation doctrine, the last act was more than a year before, and therefore that ends the matter.
Yes, and more than that, for an harassment, we believe that there has to be some kind of contact on her presence in the agency. And what happened here is that she was on vacation leave since December 17, 2010, and so she was not in the agency, she was not in the authority, she was not there, she was on vacation, and she filed a complaint a year and more after that, on December 23rd, 2011. So even in the continuing violation theory, there was no contact more than a year before she filed a complaint.
Okay. Thank you.
Do you have any other questions? Thank you.
With respect to Chief Judge Lynch questioning if the official examiner could find out that the corporation erroneously concluded the nullification of my client's appointment, yes, the official examiner could have determined that the corporation's decision to nullify my client's appointment was wrong, and that was part of what was presented to the official examiner. Now, with respect to the time bar of the harassment claim, Your Honor, there is evidence in this case that since Mr. Fortunio appointed Hernandez-Gregorat to be the executive director of the corporation, and Hernandez-Gregorat appointed Mr. Luis Sanchez Casanova as Director of Human Resources. Luis Sanchez Casanova, as Director of Human Resources of the corporation, specifically stated to my client that he was being pressured by Hernandez-Gregorat to terminate certain employees in the Human Resources Office that hold specific positions there, and that he was feeling that pressure from Hernandez-Gregorat, and he had been pressured. That's from the record, clear from the record. My client was the person in charge of the appointment division. So through my client, every appointment in the corporation had to come through. Now, the corporation, instead of following the procedure, they appointed Ms. Carrasco that had a similar position to our client, to a trust position, and began to give Ms. Carrasco several of my client duties. And that was constantly during all the process. Now, I'm sorry. The rest is on the brief, and I'm sure. Thank you very much.